questions of property law, and we're into week 9. We have a lot of material to cover this week and in the few weeks left in this term. And as we approach the end of term, a few things. The first is that by now, I trust you're well advanced with your second assessment. Just a reminder that it's due on 21 May, and I do expect everyone to submit the work on time. That said, it's a pretty realistic ambition because this cohort has been excellent in terms of responding to the requests to submit work on time. So thank you very much. The second is, if you missed it last week, we now have a date for the take-home paper, and that is Thursday, 11 June, 6:30 or 6:45 p.m. for it to be released. And it's due the following evening, Friday, 12 June, 11:45 p.m. So please finalise those arrangements that you need to make so that you can sit that exam during that time. Unlike the other assessments, there's no extensions and there's no late penalty imposed for late submission. If it's late, it's a 0. So, but don't be scared of it, because this was, as I mentioned, supposed to be a 2-hour test, and now you've got 29 hours. So it should be relatively easy. Tonight we're dealing with, we're going to deal with the broad topic of tenure, T-E-N-U-R-E. And when I hear the word tenure, I think in terms of freehold and non-freehold, as if you like broad categories. You'll recall that we talked about the way in which a landowner who owns fee simple has the ownership which is as good as it gets, so to speak. And a landowner purchasing freehold land, which is fee simple, acquires that interest from the state. It's the most complete form of ownership, but it's not absolute. The state is empowered to withhold and does withhold certain rights, such as the right to minerals or petroleum beneath the surface of the land. And of course, you don't have the absolute ownership of the space above the land in question. So that's the best type of ownership in terms of it being absolute. And we call that fee simple or freehold. Now, if it's non-freehold, it remains under the control of the state, effectively owned by the state, but may be subject to a lease or a license or a permit or a reservation, or it might be dedicated for a road purpose, or subject to no tenure at all. So when we talk about tenure, it can mean a multitude of things depending on what it is that we're looking at. Now, when I studied law, that was pretty much the end of the story. But of course, it's all changed dramatically now with the Barbo decision and significantly the introduction of the Native Title Acts, both federal and state. So the Native Title Act 1993 Commonwealth and the Native Title Queensland Act, also 1993. So when you consider the ownership of land, tenure if you like, you need to consider the type of tenure and have a feel for how that might work in with issues to do with native title. In a way, they're two separate but interlocking systems. And there are other provisions, mostly statutory, that have a bearing on the tenure of a property owner or someone with a property interest. So, for example, you need to consider whether the Land Act may apply in certain ways. There may be an administrative decision under the Land Act that has to be considered. There's local government legislation, and there's other legislation which we deal with in environmental law, such as Nature Conservation Act, Biodiversity Conservation Act, Contaminated Land Act, etc. And the Contaminated Land Act has a conveyancing aspect, which we deal with in more detail in conveyancing. Just as a practical way of seeing how this works if you ever find a certificate of title for ownership of real estate, have a look at the way in which there are reservations regarding minerals and petroleum rights, which are part of the Torrens system. Now, the Torrens title is a way of recording land by registration, and it's a way of recording the interests that people might have in land as well. Now, not all interests, but many interests are recorded on Torrens title. So when we think about ownership of property, one of the first things that we might do from a practical perspective is have a look at the titles maintained by the Registrar of Titles and have a look at things to do with the registration of interests. So if you own a piece of land or a house or something of that nature, then you are the registered owner on the title, and it's subject to any other interests that may affect the title. A very common one, of course, is a mortgage in favour of the financier that assisted you to acquire that interest. The case that probably is most often cited for you to consider in terms of the way this works in practice is a case called Breskvar and Wall. That's BRESKVAR against Wall, WALL. The citation is 1971, 126 CLR at 376. And Chief Justice Barwick at the time spoke of Torrens system as one where title to land is derived by registration. It's a system of title by registration and not one of registration by title. So registration is a key element. So Breskvar and Wall is the case that you should cite if you're looking to, I guess, explain the registration process. And we did talk briefly about Torrens title last week, and you can distinguish Torrens title to old system title. And the old title system of land ownership goes back to medieval times and involved someone proving that they acquired their interest legally from the predecessor in title, usually by producing a contract. And of course, the predecessor in title did the same thing, as did that person, as did the person before, so that it became very cumbersome, where in order to establish that you owned property, you needed to produce a string of documents to establish continuous title since the original deed of grant from the Crown to the original landowner. And of course, that creates all sorts of difficulties, doesn't it? Fraud was rife, and if you have a missing title, then of course you've got a break in the chain of title, which creates all sorts of difficulties as well. So in broad terms, Torrens title means that we establish individual lots by producing a survey plan done by surveyors, presented to regional councils, sealed as a registered survey plan, lodged as a survey plan, used to be called a registered plan, at the titles office. And on each one of those survey plans are a number of individual lots. Now that can apply to flat land, and I mean flat land in the sense of non-strata title, or it can be a community title, such as a body corporate situation, either strated laterally, vertically, or horizontally, if you understand what I mean. So, and they're called community titles, CMS. So the Torrens title works on your ability to simply show that you are now registered as the owner on the title, and that's the way that you establish your claim to ownership, rather than producing the documents of all the predecessors. I hope that makes some sense. Are there any questions about Torrens title, registration, the way in which various interests are recorded on title, reservations to the Crown that we've discussed already? It's all a bit heady, but it's actually it's very practical and it's very important.
I live on a strata title, so we have 500 lots in our estate, and we're part of a body corporate because we have a communal facility, which is like a gym and a pool and whatnot. So that's how ours works here.
Okay, very good. Yes, and all of that would be recorded. So it's a little more complex when we have, if you like, for want of a better term, strata title or community title, as we say, but along the same principles. And
Because
Amy
we are
says,
governed under the Owners Corporation Act.
yeah, and body corporate community titles, etc. Amy talks in the comments about compensation agreements, and that was an interesting area as well. So thank you for that. Okay, so when we talk about land title and Torrens title in Queensland, the key piece of legislation, which I'll ask you now to bring up on your screens, and if you're watching as a recorded session, please do so, is the Land Title Act. And I'll ask you to look at section 37 of the Land Title Act as our introduction to indefeasible title. Land Title Act, Queensland. Can anyone tell me the year that that was enacted?
1994.
Correct. Thank you, Amy. And that was a big year for property-related legislation, as was 1974. So the section 37 talks about the creation of indefeasible title. And Chief Justice Barwick in Breskvar and Wall talked about indefeasible title. An indefeasible title for a lot is created by the recording of the particulars of the lot in the Freehold Land Register. An indefeasible title is referred to in section 38, which provides a meaning. And indefeasible title is a lot where the current particulars about that lot are recorded on the Freehold Land Title Register. So it's the process of recording the interest on the register that creates the indefeasibility, which is what Chief Justice Barwick was talking about in that comment I made earlier. So have a look at section 38. Also have a look at section 41B, which talks about the meaning of indefeasible title for common property, which is as Tammy was describing it. Now, when it comes to interests, I mentioned that not all of them are recorded on the title registry records. Most are, but some aren't. For example, typically short-term leases, that is for a lease for a period of 3 years or less, is not necessarily recorded on the title. And it will have claim, the owner of the lease, the holder of the lease, will have indefeasible title, even though it's not recorded on the title. But that's not absolute. For example, if there's an option contained within the lease, that option may not be binding against a subsequent owner of the property. And that's Friedman and Barrett from, I think, 1960 Queensland reports. So it gets a little technical here, but work with me. Understand the importance of registration, which we link directly to indefeasibility, and note that there are some exceptions to that. Just on the point of leases and jurisdiction, which I often come back to, it's all very well to know your rights, but you need to know where to go. Just a quick word about the Queensland Civil and Administrative Tribunal. It has jurisdiction to deal with retail shop lease disputes. That comes about as a result of the Retail Shop Leases Act 1994. Amy will tell us for that one as well. And a retail tenancy dispute is in relation to the use or occupation of leased shops under the retail shop lease. And it's fair to say, I think, that all retail shop leases are essentially commercial leases, but not all commercial leases are retail shop leases. So retail shop leases is a huge subset of commercial leases, but not everything. So if you have a commercial lease arrangement, a threshold question in practical terms is this a retail shop lease or is it a non-retail shop commercial lease? If it is a retail shop lease and there's a dispute, Tanya says medical is not. That's correct. 99% of the time. We'll come back to the exception in a sec, unless you can tell me. If you have a dispute in relation to a retail tenancy dispute, then provided the amount in dispute is up to $750,000, which is the district court threshold, that matter is decided in the Queensland Civil and Administrative Tribunal, which has exclusive jurisdiction. So there's a more common misconception that QCAT only deals with matters up to $25,000. That's true generally in what's called the minor civil disputes jurisdiction of QCAT, but QCAT has a whole range of different jurisdictions. So anything that's not that MCD is generally either unlimited or, say, in the case of retail shop leases, $750. So basically, a lot of QCAT work is kind of district court or Supreme Court parallels in terms of sharing of jurisdiction. I hope that makes sense. All right. When can a lease of a commercial premises used for medical purposes be a retail shop lease when for 99% of the time it's not?
I know that.
Michael, do you have an idea? Or are you just unmuting?
Okay, we're going to support it.
Can you hear me?
Yes, Michael. All right. Does anyone have any thoughts on when a lease that wouldn't appear to be retail in nature can be covered by the Retail Shop Leases Act? The answer is in certain circumstances where it's part of a retail shop lease centre as defined under the Act, which is quite particular. So there are little tricks here. And we deal with a lot of those sorts of things in land law and then conveyancing as well. So what we're talking about tonight is a little taste of things to come in some ways. All right. Any questions, comments? No? The retail sale of medical goods is a retail shop lease. Yes, I agree with that. Now, when we talk about land, public land is part of the exercise for tonight, we generally mean that which is owned by the Crown. What is the Crown? I like to think of it as the public parallel to the term family, in that if we have a family, we have, mum and dad and kids, uncles, aunts, parents, we have individuals that we associate in a certain way, but the overall collective, for want of a better term, and it's a bit loose, is family. Crown's a bit like that. We have governments, we have executive, we have departments and agencies, and sort of this is all kind of the Crown, for want of a better term. So the state plays a critical role in relation to public land in a number of ways. Now, we've talked about one of them already tonight, and that is that the Crown derives its title through radical title as opposed to native title as the original source owner of public land. It then can hold that land and deal with it in certain ways. It might freehold it by issuing a deed of grant, or it may retain effective ownership and lease it, or use the land for public purposes, or reservations or parks or something else along those lines. Now, generally speaking, when we're talking about freehold and things like commercial leases and mortgages, things of that nature, we tend to look towards the Land Title Act. So the Land Title Act deals with that property which has been essentially freeholded, with fee simple land, which is numerically the great bulk of the land, say in Queensland. That which is still non-freehold land, we tend to think about that in the context of the Land Act. Now, can anyone tell me what year the Land Act was enacted?
94.
94 again. Yeah, as I said, it's a big year for legislation. So the Land Act deals with different categories of tenure. There's non-freehold land, which is the bulk, if you like, of what the Land Act is all about. Unallocated state land, state leasehold, and freeholding tenure. I'm going to ask if you could call up the Land Act 1994 Queensland now. I'm going to identify some important sections, and I want you to look at that during this week in the context of particularly that land in Queensland that is non-freehold. So some of the key sections, if I could just make a note. Section 4 talks about the objects, always a great place to look. And when you look at section 4, you'll see that the objects are very wide. I'll come back to that. Section 5, that talks about unallocated state land, which was formerly known as Crown land. Section 15, which talks about the process of issuing freehold leases. Sections 155A and B, which is where, if you like, the Crown can grant leases for up to 100 years. You see that sometimes in commercial resort type developments where the Crown, the state, wants to retain ownership but wants a resort developed. So they might issue the developers, the owners of the resort, a 100-year lease. The resort is developed. Then when you come to buy a unit in the resort, what you might be acquiring is the sublease of a 99-year lease. I hope that makes sense. Section 28 is important in the Land Act. This is really important, actually, because it talks about the interaction of the Land Title Act, the Land Act rather, and the Native Title Act, Commonwealth. Chapter 6 deals with the process of registration and dealings generally in the Land Act, and section 275 talks about the registers comprising the land registry. So we'll go back to section 4. I mentioned the objects. I said they're very wide, and you'll look at some key terms there. That in administering the Act, the people of Queensland are to benefit, and therefore the land must be managed for the benefit of the people of Queensland, having regard to a number of key principles such as sustainability, development, community purpose, consultation and administration. And we see that term sustainability a lot in environmental law, as you might expect. Good unit to take, environmental law, just as an aside. Now, I mentioned the interaction between the Land Act and the Native Title Act. Have a look at sections 27 and 28. 27 says that the object of the part, which section 27 is included, is to deal with land in a way that is not inconsistent with the Native Title Act Commonwealth and the Native Title Act Queensland. And essentially that statement is replicated directly in section 28 that says any action taken under the Land Act must be taken in a way that is not inconsistent with the native title legislation from 1993. So to remove any doubt, it's declared that if native title exists over land, the land may still be dealt with under the Act. And it talks about actions that might be undertaken. And action includes a whole range of things, including granting land, dedicating land as roads, dealing with providing permits, and dealing with state forests and timber reserves, etc. Now, when it comes to native title, we need to then understand what it means, because in the Land Act it says that what action is taken under the Act, which is a whole range of things, must not be inconsistent with native title. So what does native title mean? Well, native title is actually defined in the Native Title Act. This is a bit obscure, in section 223 subsection 1. So very quickly, either to add to the screen or replace the screen, go to the Native Title Act, Commonwealth, 1993. No coincidence that this led to a whole range of legislation in Queensland in 1994. And you'll see the definition of Native Title Act in 223. So it talks about the communal, group or individual rights and interests of Aboriginal people and Torres Strait Islanders in relation to land and waters possessed under traditional law and custom by those people that have a connection with an area recognised under the Australian law. So there's a whole lot of words there that relate to individual topics where native title claims are considered. So it talks about Indigenous inhabitants, meaning native title Aboriginal or Torres Strait Islander people who are the only people with the capacity to hold native title. Now, section 223 of the Act, the Native Title Act, talks about native title within the context of common law rights and interests. And it means those communal, group or individual rights and interests in relation to land or water in certain stated circumstances. And it talks about hunting and gathering and fishing covered within the context of that section. So section 223, I think, is a good starting point if you're trying to understand the mechanisms of the Native Title Act. Now, of course, so far, if you've been listening really carefully, you would have noticed that I've introduced native title within the context of distinguish it to the Land Act. And the Land Act, you'll recall, I'm categorising as essentially non-freehold, which then begs the question, how does native title fit with the issue of freehold land and, if you like, the Land Title Act, which we use as a contrast to the Land Act? So under the Native Title Act 1993 Commonwealth, the valid grant of freehold estate, fee simple, other than certain types, but not many, on or before 23 December 1996 is known as a Previous Exclusive Possession Act. This means that native title has been extinguished over those areas. And when you think about what may have been developed and freeholded before 23 December 1996, That's huge tracts of land within Australia, particularly the urban areas would fit in with that category. So that means that native title has been extinguished by legislation over those areas, which means that we're really talking about applications for native title in a different context. Have a look at section 23A of the Native Title Act, which provides an overview of the division of the relevant division, which relates to confirmation of past extinguishment of native title by certain acts. And that division, which is referred to in section 23A, provides that certain acts attributable to the Commonwealth, which were done on or before the 23rd of December 96, will have completely or partially extinguished native title. So it's important to understand whether a particular act, I'm not talking about legislation now, but a small a act, relates to a previous exclusive possession act. If the acts were previous non-exclusive possession acts, they will have extinguished native title to the extent of any inconsistency. Have a look then at section 23B, which provides for issues around previous exclusion possession acts. And I'll just summarise briefly 23B of the Native Title Act. What it does is define exclusive possession acts, which we're talking mostly about freehold estates and some leases before that critical date, 23 December 1996. So an act is a previous exclusion possession act if it's valid and it took place before that time, and essentially it consisted of the granting or vesting of a scheduled interest or a freehold estate. Have I completely lost you, or are you kind of getting a feel for it? We're getting nods. I'm going to be optimistic and say we're getting a feel for it. I'm going with the latter. No,
I was nodding as in I'm lost. Sorry to say.
Yeah.
Yes.
What I'm going to do is I'm going to ask you to take down a note of the key sections and maybe work through them. And then I'll show you. I know it's tough. It's tough tonight. Actually, the whole unit's pretty tough, I think, because we deal with a lot of topics and it's not as concrete. But we'll have a look at the Native Title Registry, and that's pretty good. So I'll show you that website shortly. So just as a little recap, what we've done so far tonight is we've identified, let's say in Queensland, that we have numerically most lots which represent parcels of real estate, which are now subject to an interest which is fee simple. And we call that process of land becoming fee simple, we call that freeholding. So when we talk about freehold and fee simple, it's kind of interchangeable in its context. It's kind of the best type of ownership, but it's not absolute. We contrast that in Queensland to essentially whatever's left, which is reserved to the government, to the Crown, which is non-freehold land, and most of that is Crown leasehold, but not all of it. Some of it's roads, some of it's national parks, no, some of it's something else. But that which is not freehold is normally held by the Crown. Crown might do certain things with it. Freehold, think Land Title Act. Non-freehold, think Land Act. Both 1994. Both have their processes and they work in conjunction with each other. And when I studied law, that was it. That's all I had to worry about. But now we have this third huge regime, which is native title. So what I'm doing is pointing you towards the sections that will best have you understand how these mesh in together. The specific sections, for example, in the Land Act, that deal with the way in which non-freehold land relates to native title land. And now we're just dealing briefly with the way in which freehold land deals with native title. But essentially, in broad terms, once land is freeholded, then that will have the effect by law of extinguishing native title. So the native title claims really, this is why I started with this introduction, but this contrast between native title and the Land Act, because that's the parallel that you should consider. But do have a look at those various sections that I've referred to and try and map that out for yourself and have them ready to answer a question, for example, if need be.
I have to say, John, that even with your explanation of that, it still feels a bit contradictory. Like the fact that native title exists and then the fact that it can be extinguished so easily doesn't really feel like justice is being served.
Yeah,
in my opinion,
well,
anyway.
No, that's true. There is that. There is that. But of course, again, you know, when I was studying law, it was all terra nullius. It's vacant land, nobody owned it, and that was the end of the story. So native title applications under the Native Title Act, Commonwealth, have a look at section 61, and it talks about restrictions on making certain applications. So claimant applications can't be made in relation to areas covering previous Exclusive Possession Act areas in certain circumstances. So have a look at section 61A. And I mentioned that native title is limited to applications, limited to certain parties. So native title party is a term that's often used to refer to Indigenous parties to a variety of agreements or legal actions or proceedings under the Native Title Act. And the Native Title Act provides for a number of regimes for resolving matters. For example, one thing that is included in that Act is that certain native title parties have the right to negotiate and the right to file, the right to negotiate applications. So it means that they meet certain statutory criteria in order to do so. As negotiation parties, have a look at sections 253 and 29(2), it's 29 subsection 2, and section 30, all of the Native Title Act. Then look at what we mean by a negotiation party. So do some research on that. It's essentially an individual or a group or an organisation that may participate in a party, or as a party rather, in proceedings in a right to negotiate, usually involving the government or some other native title party. A term that we've used a number of times already that you need to be familiar with in this context is the term extinguishment. So extinguishment is the term used to describe Australian law that does not recognise native title rights and interests because, and Lachlan will say this is unfair, but it's just the way it is, because the governments have done something or allowed people to do something in the past that has now made native title recognition legally impossible.
Well, the amount of things that I think are unfair, John, the
okay.
entire reason I'm doing my degree so that I can help to make changes.
Thank you. Well, that's good. And you're not doing your job if you're studying or practicing law, if you don't challenge things and you don't look to ask questions, why is this right? And if it's unfair, then you pursue it.
Well,
So I'm not
speaking of
saying it's unfair,
people,
I'm just saying if that's your
sorry.
view. Yeah.
I was going to say and I'll say this really quickly because I do have to leave shortly. Speaking of people that have made a lot of changes, the thing that I mentioned in the chat box before was that I am trying to facilitate a Zoom session with Justice Kirby for anyone that's interested. He's a good friend of the Vice Chancellor of the uni, and the Vice Chancellor is keen to get it happening. So anyone that would be interested in attending the Zoom session with Justice Kirby, talking about law and some of the changes that he would have gone through over his many years, you know, on the High Court and whatnot. Yeah, let me know. Anyway, sorry to interrupt. I'll let you get back
No,
to
that's
it.
fine. And just on another aside, I'm a member of the Human Rights Committee of the Queensland Bar Association. So even though I'm now, I'm not a barrister anymore, and I don't have the right to practice as a barrister, I'm still part of the Bar Association. And in the Human Rights Committee, Michael Kirby is very, very active and encouraging the committee to look at certain things. I better not say any more than that, but
Oh well, that was the other reason I mentioned it, is because even because you are a magistrate and whatnot, with the amount of stuff that you've done over your time in the legal industry, it'd be amazing to have you be a part of that conversation as well, John, if it's something you're interested in joining.
We'll see. I've got to be very political and quite neutral now. It's a bit different.
Diplomatic, yeah.
Yeah. All right. So
Sorry, John, just to
Yes, sorry.
interrupt,
Yes,
can you explain section 11 of the Native Title Act, Commonwealth?
I haven't got it on the screen, embarrassingly.
Well, that's extinguishment of native title, and it says, subsection 1, native title is not able to be extinguished contrary to this act.
Yes, that's right.
Okay.
Yep. And I made some notes, but I didn't make a note of the section. So yes, but remember, of course, that we're talking about past acts here. So the issue around previous exclusive possession acts is essentially a way of, from a practical perspective, saying, okay, as from this date, what's done is done, but in the context of extinguishment, we now look at how native title claims might be brought in certain ways. So section 11, thank you. I'll need to look at that in more detail, but thank you, Tammy. So, but generally speaking, the things that have been done by the passing of law or the granting of interests that are inconsistent with the continued enjoyment of land of native title can create this extinguishment. Now, as we've discussed in property law pretty much all the way through, property is essentially a bundle of rights, and it's the same principle for native title. Native title is also, if you like, for want of a better term, a bundle of rights. Now, complete extinguishment, when that does occur, is when the entire bundle of rights is extinguished, but it might be partial. And generally, once the rights have been extinguished, native title rights can never be recognised again by Australian law. But in certain circumstances, the Native Title Act does allow courts to ignore the effect of the extinguishment. That can happen in some circumstances. So when you're studying this area, you will need to have some understanding and a good definition for previous exclusive possession acts, PEPA, and broadly, previous exclusive possession acts include valid or validated grants of freehold and some leases and some public works. And these do extinguish native title claims. The section to look at there is section 23C of the Native Title Act. So the previous non-exclusive possession acts are valid or validated grants of non-exclusive agricultural or pastoral leases before 24 December 1996 or after 23 December. And in that regard, the key decision for when we're talking about pastoral leases and native title is the WIC decision. I hope we've heard about this or read about it, but it's WIK. So the decision of the High Court in WIC Peoples against the state of Queensland, it's 1996 187 CLR 1. And that is authority for the proposition that, depending on the terms of the lease, non-exclusive native title rights and interests may coexist with the rights of non-exclusive pastoral leaseholders. So apart from Mabo, the next case you should cite and consider in this space is WIC. They're the two key cases. I've mentioned extinguishment. Now we've introduced this concept of coexistence, and that's a term that you'll need to identify, have ready to explain, and it refers to the existence and the exercise of native title rights, as the name implies, sitting alongside the rights of others over the same area of land or waters. For example, native title rights go onto land and hold ceremonies that may coexist with the rights of pastoral leaseholders to graze cattle. So it's about sharing of the land that recognises everyone's rights and interest in the area. That's what we mean by coexistence. I mentioned earlier the National Native Title Tribunal. So that's an independent statutory body. It's established under Section 107 of the Native Title Act, and it provides for a wide range of powers and functions under the Act. So if you want a very good resource and a good way of getting to feel how this works in practice, I'd recommend that you look at the website for the National Native Title Tribunal. And for example, you can undertake searches of the National Title Register, which contains determinations of native title by federal courts, the High Court, the Federal Court, recognised by Supreme Courts of the states, etc. So that's a good resource to look at. And the Register of Native Title Claims is also on the website, and you'll see there that it includes the details of native title claimant applications that have been filed with the Federal Court, referred to the Native Title Registrar, and have generally met the requirements for registration. The other thing that you might need to consider within this context is the distinction between past acts and future acts. So generally speaking, a past act is a legislative act before 1 July 93, which is invalid to the extent because of the existence of native title. Have a look at section 228. And then look at future acts, which is a proposed activity on land or water that may affect native title. So an example of a future act might be a proposal to grant a mining tenement or a proposal for the compulsory acquisition of land. So a future act might be invalid to the extent that it affects native title unless it complies with certain procedures as set out in the Native Title Act. Now, the Native Title Act provides for the government to, intending to undertake these future acts, to make an application, to negotiate, and that's why it's important that the native title party does have this right to negotiate. Because, you've got to know, the government's got to know with whom they should be speaking about these issues. And if the matter does go before the tribunal, the National Native Title Tribunal, the tribunal works to various criteria and have a look at section 39 of the Native Title Act, which deals with the criteria for making arbitral body determinations. I won't go through that in full, but I would urge you to look at section 39 just to get a feel for the parameters. Ultimately, as I mentioned, claims can be registered. So that's all subject to the registration test. And the registration test is a set of conditions set out in the Native Title Act applied to native title claimant applications. And essentially, if the application meets all of the criteria, it will then be included in the Register of Native Title Claims, which means that the claimants then have the right to negotiate together with other rights while the application is underway. And so a very key important part of the discussion is around right to negotiate, as I've mentioned a few times. And coupled with this right to negotiate are some other rights, such as the obligation to negotiate in good faith, and that's all included in the Act as well. Another key term is authorisation. And authorisation is the process by which the native title owner must use to give permission for various agreements. And then there's another concept is certification. And in that regard, have a look at section 203 BE of the Native Title Act. 203 capital B capital E. When you look at the Act and you consider what's contained within the website for the National Native Title Tribunal, you'll see that there are elements of case conferencing and mediation, which are important concepts, and it promotes alternative dispute resolution, which is another good unit to consider of study. And it talks about the process, preliminary conferencing, mediation, case management, and have a look at section 150 of the Act, which deals with conferences within that case conferencing within the context of applications. I told you we had a lot to cover tonight. When you're looking at the material, also consider what we mean by without prejudice privilege. When we're talking about without prejudice means it can't be raised essentially in later proceedings. So it's a legal privilege and it attaches to discussions and conferences in without prejudice settings, such as mediations and negotiations aimed at resolving the matter by agreement. So parties have an obligation to pursue a resolution through alternative dispute resolution that will lead to this without prejudice discussions. And as I mentioned earlier, all of the discussions need to be in good faith. And have a look at sections 31, which talks about the ability to have the right to negotiate. And then more specifically, section 136B, which talks about the obligation to proceed in good faith. Other issues to do with native title. When we talk about on country, what that means is simply going to the relevant area of land so that the mediation conference or even the hearing might take place on country, which means on or near the area covered by the application itself. As a result of the discussions, the parties may enter into what's called an Indigenous land use agreement. I mentioned that there can be this issue of coexistence. So Indigenous land use agreements can cover areas of native title that have been or have not yet been determined. And they can be entered into whether there's a native title claim or not, and they can cover things like access to an area, extinguishment of native title, compensation, employment, cultural issues, mining. So when we talk about having this emphasis on alternative means of resolving disputes, these voluntary agreements that we call Indigenous land use agreements are very important because it allows parties to have an important say in what's being determined and mould an agreement for themselves that makes some sense. Finally, if all of that fails and there is a native title claim, there's a prescribed form. Usually the matter will go to the federal court, and it may be a compensation claim, which is again a different prescribed form for a native title determination application. So you might have a look at the Tribunal website for that. There is a bit more, but I dare not take it any further than I've taken it tonight. I do always thank you at the end of each session for being patient and bearing with me, and especially so tonight, because I know it's tough, but it's a really interesting area of practice. Those people that do practice in native title, I think, are very fortunate to have such an interesting area. And it's an area that's extremely important. All right. Are there any questions or comments?
John, Ivan here. I basically think Australia's doing a pretty good job. I was raised in Ireland. It's been distressed by all sorts of conflicts, and the battle over land is not unique to Australia. But I think since Mr. Mabo opened our eyes, we've made a pretty sterling response in trying to rectify. And we carry the baggage of history and the doctrine of tenure that makes it all the more difficult. Had it have been something like a dodal land in the US, it might have turned out a bit different, but I think that there's a considerable amount of goodwill in the judiciary and in Australia to try and rectify wrongdoings of the past. So I'm a bit charitable. But I do note that sometimes the bar is set very high. I think I read Ward during the week, and I think the Indigenous people in some areas have to reach a very high bar to get their claim established.
Just lost you there, Ivan. No, thank you very much for those comments. And I've got to say, I agree with your sentiments, Ivan. Thank you for that contribution. That was excellent. All right. Any other questions, comments? Okay. And to answer a question, I have taken land law in the past, but I've never taken legal advocacy at this uni. I think Scott Beattie takes that. Very good unit as well. All right. So some of you have to go to evidence law. So all the best. We'll see you next week. Thank you. Bye.
Thank you.